Following our discussion on the Groundwater Management Act of 1980, one of the most significant outcomes of this legislation was the creation of the concept of grandfathered groundwater rights. These rights were designed to balance the protection of existing agricultural and industrial users with Arizona's goal of conserving groundwater for future generations. For real estate professionals, understanding how these rights are established, maintained, and transferred is critical when dealing with irrigated land, especially within the active management areas, AMAs, established by the Act. Under the Groundwater Management Act, groundwater rights within AMAs were divided into specific categories based on historical usage prior to the Act's adoption on June 12, 1980. These rights, known collectively as grandfathered rights, allow continued groundwater use within defined limits, but prevent expansion beyond previously irrigated acreage or previously authorized volumes. Grandfathered rights are tied to the land itself, rather than the owner, meaning that when ownership of irrigated land is transferred, the water rights generally transfer with the property, provided that the transfer complies with Arizona Department of Water Resources ADWR regulations. The three types of grandfathered rights recognized under ARS, Paragraph 45,463 through Paragraph 45,465, are irrigation grandfathered rights, IGFRs, Type 1 non-irrigation rights, and Type 2 non-irrigation rights. Of these, irrigation grandfathered rights are the most relevant to farmland transactions. These rights authorize the owner to withdraw groundwater to irrigate the same acres of land that were legally irrigated during the 5 years preceding the Act, 1975-1980. However, once a property with IGFR is permanently converted to a non-agricultural use, such as residential or commercial development, the right cannot revert to irrigation. When irrigated land with grandfathered rights is sold, the transfer process must be recorded with the Arizona Department of Water Resources to ensure that the rights remain valid under the new ownership. ADWR requires submission of a Notice of Change of Ownership for grandfathered rights form. This notice must include the parcel number, well registration number, if applicable, and a copy of the recorded deed showing the new owner's name. The ADWR then updates its registry to reflect the change and confirms that the rights have not been forfeited due to non-use or unlawful expansion. For example, consider a 160-acre farm in the Pinal AMA that was irrigated continuously before 1980. The land carries an irrigation grandfathered right, authorizing irrigation of those same acres. If a buyer acquires the property, the buyer also acquires the IGFR, but must notify ADWR within 30 days of closing to ensure the water rights remain valid. If the buyer later converts the land to residential development, the IGFR is extinguished, though a Type 1 non-irrigation right may be issued to allow groundwater use for the new non-agricultural purpose within defined limits. It is crucial for real estate professionals to recognize that groundwater rights do not always automatically transfer in other contexts, such as leased farmland or trust land. Additionally, failure to file the proper transfer documentation can result in confusion over ownership of the rights or even the forfeiture of the groundwater allocation. Therefore, agents and brokers must exercise reasonable skill and care by confirming with ADWR whether water rights are attached to the property and assisting clients in completing necessary forms during escrow. The implications of these rights extend beyond agriculture, because grandfathered rights can enhance the value of irrigated land by guaranteeing access to water within strict conservation frameworks. They are a significant factor in property appraisals, investment analysis, and land use planning. A property with transferable IGFR may command a higher price than a similar parcel without water rights, especially in regions where surface water supplies are limited. The Arizona courts have consistently upheld the need to protect the intent of the Groundwater Management Act while honoring legitimate existing rights. In Cherry v. Steiner, 543 F. Sup. 1270, D.Rs. 1982, the court affirmed the constitutionality of the act, stating that restricting groundwater pumping did not constitute an unconstitutional taking of property. This case remains a cornerstone for understanding Arizona's balance between private water rights and public conservation goals. Review summary. Grandfathered groundwater rights, created by the Groundwater Management Act of 1980, protect pre-existing groundwater users while preventing further aquifer depletion. These rights, particularly irrigation grandfathered rights, are tied to the land and typically transfer with ownership, provided that the new owner properly records the change with the Arizona Department of Water Resources. Real estate professionals must confirm the status of these rights in any farmland transaction and ensure that the transfer complies with ADWR requirements. Discussion prompts. Why were grandfathered groundwater rights created as part of the Groundwater Management Act? Answer. To preserve the rights of existing groundwater users while preventing further overuse and depletion of aquifers. What must a new owner do after purchasing irrigated land with grandfathered rights? Answer. File a notice of change of ownership with the Arizona Department of Water Resources to update the state's registry and maintain legal recognition of the rights. Why might farmland with grandfathered water rights have higher market value? Answer. Because it guarantees access to groundwater within defined conservation limits, making the land more viable for agricultural use or conversion to other lawful purposes. Closing remarks. The transfer of irrigated land with grandfathered water rights embodies Arizona's delicate balance between individual property rights and the collective need for water sustainability. For real estate professionals, understanding these laws demonstrates not only compliance, but also the expertise to guide clients through complex transactions involving agricultural and rural lands. Water rights are often as valuable as the land itself, and protecting them requires precision, knowledge, and diligence. Supporting sources and key case law. Case. ARS. Paragraph 45, 462 to 45, 465. Grandfathered rights provisions. Arizona Department of Water Resources. Groundwater Rights Transfer Procedures, AAC. R12, 15, 722. Reporting and Transfer Rules for Groundwater Rights. Cherry v. Steiner, 543F. Sopica, 1270. D. Ares, 1982. Constitutionality of Groundwater Regulation, AAC. R4, 28, 1101H. Licensee's duty to disclose material facts affecting property value.